Hafaday and good evening, ladies and gentlemen. This public hearing on bills number 283-34 COR and 284-34 COR is hereby convened by the Guam U.S. Military Build-Up Infrastructure and Transportation. As was mentioned a little earlier, bill number 283-34 is an act relative to requiring the notification, reporting, and posting of Chamorro Land Trust Commission land leases and licenses. And bill number 284-34 COR is an act relative to establishing a temporary moratorium over Chamorro Land Trust Commission land leases and licenses until administrative rules and regulations as required by 21 GCA have been duly adopted and added to the Guam Administrative Rules and Regulations, temporarily reducing the salary of the Director of Land Management by 25% during the moratorium, suspending the authority of the Department of Land Management Director over the CLTC during the moratorium, abolishing the position of Administrative Director of the CLTC, appointing a temporary receiver during the moratorium, and authorizing the voiding of any improperly awarded CLTC lease or license. Just for the information of the public, these two measures were introduced in early May, and this public hearing is being conducted to ensure that we comply with existing law that requires any legislation that will be entertained by the main body has to receive a public hearing. I want to also provide just a little bit of background information. Back in May, there were some serious concerns brought up by members of the media and also by a former senator who has joined us this evening to provide his testimony with regards to some of the activities taking place at the Chamorro Land Trust Commission. What was discovered was that, in fact, there were a number of situations such as the Barrigada Heights development and distribution of land leases that were questionable because some land leases were being distributed to family members of staff, and also some land leases were being distributed to staff members, fellow staff members within the Chamorro Land Trust Commission. In addition to that, it was also shared with members of the body that as recent as 2 weeks ago, that 4,607 land lease applicants in the month of December alone in 1995 were skipped, when in fact the law specifies that the individual applicant shall be entertained on a first-come, first-served basis. So with a number of these discrepancies, the Attorney General's office was included in the process where she opined, the Attorney General opined with regards to some void, null and void leases and some voidable leases. In this particular case, we have an excellent attorney in front of us who perhaps may want to clarify that particular differentiation. But in this case, it's about restoring the integrity of the process for the Chamorro Land Trust applicants and ensuring that these leases that are distributed are in compliance with existing law, and that in fact the applicants who are pending know exactly where they stand in terms of future distributions of land leases. So I'd like to recognize former Senator Robert Klitsky, who has joined us this evening to provide his testimony. Senator Klitsky, you may proceed.
Thank you very much, Mr. Chairman. Honorable Chairman Frank Bleshogan Jr. and members of the Committee on Guam Military Buildup, etc., I appear before this honorable committee to lend my wholehearted support to Bills 283 and 284 and to offer the suggestion that provisions of Bill 304 be incorporated into Bill 284. The label of the paper attached here too reads in pertinent part, quote, I appear before you today to testify in favor of Bills 283, 284, and 304-34. Today was July 13. Because Senator Tom Addis summarily canceled the hearing set for 4 p.m. on that day in favor of a session that never happened and didn't reschedule that hearing, this testimony was quite effectively squelched until today. As I read that testimony today, I ask that you remember the temporal disconnect caused by Senator Atta's failure to reschedule a hearing. While I will read my July 13 testimony into the record today, 2 sentences from that testimony must be excised and set forth herein. First, quote, "Only the most naive among us would proceed on the basis that the same people who created, abated, benefited from, or ignored the scandal can be trusted to bring it to an end." Here, with respect to naivete, the immortal words of Walt Kelly's Pogo are appropriate. We have met the enemy, and he is us. Naivety in this august body abounds to the effect that that same Tom Atta would introduce Bill 356, suggesting that 7 others are naive enough to pass this rather transparent attempt to sweep the entire CLTC scandal under the rug. Or is it naivete that Atta is looking for? Second, this crucial remedial legislation should have been passed in May. On April 19, Mount Barragata residents reported drainage concerns caused by a newly bulldozed road leading from Route 16 into the boonies. The road led not only into the boonies, but ran smack dab into a Pandora's box of untrustworthiness, incompetence, legal, ethical, and moral problems involving, among others, DLM Director and Deputy Director Michael Bora and David Camacho, Chamorro Land Trust Commission Chair Pika Fairan, Senator Regine Lee, employees of the CLTC, one of whom confessed on camera to a violation of 4 GCA Section 15204. Rather than move these bills forward, Atta allowed the situation to molder to the general disgust of all except the CLT, which recently announced its investigation of itself and its staff showed no wrongdoing. I respectfully request the swift passage of these 2 salutary bills. And now, Mr. Chairman, I'm going to read the testimony that I should have presented on July 13. This crucial remedial legislation should have been passed in May. On April 19, etc., the road led not only into the boonies, but ran smack dab into a Pandora's box of untrustworthiness, incompetence, legal, ethical, and moral problems involving inter alia DLM Manager, Azure Director, and Deputy Director, respectively, Michael Bora and David Camacho, Chamorro Land Trust Commission Chair Pika Fairan, Senator Regine Lee, employees of the CLTC, one of whom confessed on camera to a violation of 15 GCA Section 15204, which reads in pertinent part, quote, "Fair treatment. No employee shall use or attempt to use an official position to secure or grant unwarranted privileges, exemptions, advantages, contracts, or treatment for himself or herself, a spouse, children, or others, including but not limited to the following." Now, I said then, in deference to the many others who wish to testify in this important remedial legislation, I'll forego this opportunity to catalog the nonfeasance, misfeasance, and malfeasance brought to light by the discovery of the Booney Road, realizing that to do so would be to engage in a superfluous soliloquy. The extensive media coverage of what is now known as the CLT scandal suggests that all and sundry, especially CLTC beneficiaries, are painfully aware of all that they have done and what they have failed to do. Rather than cataloging the multitude of problems emerging from Aguon Pandora, I'll spend my time parsing the salutary provisions of the proposed remedial legislation and, figuratively speaking, relate the cure to the illness. Bill 283, which dovetails nicely with Bill 284, provides an important safeguard against the kind of lack of trustworthiness that is emblematic of the CLTC scandal. The bill would add a disclosure provision to the body of law encompassed by the CLTC organic legislation requiring publication of the details of an intended award of a lease or license. But the track record for trustworthiness, accuracy, diligence, competence, and especially transparency of current Director of Land Management Michael Bora suggests that a safeguard is necessary. In order to ensure that notice is published, the following language is suggested. This is suggested section 75.126.1. The Director of Land Management shall record his declaration under penalty of perjury of the publication of the section 75.126 notice in the chain of title of the lease or license, notice of which is published pursuant to section 75126. The recordation of the Director's declaration is a condition precedent to the recordation of the lease or license. Bill 284, which dovetails nicely with 283 and 304, is necessary to clean up the mess which created and is created by the CLTC scandal. Only the most naive among us would proceed on the basis that the same people who created, abated, benefited from, or ignored the scandal can be trusted to bring it to an end. In order to restore trust in the CLTC, a trustworthy person must temporarily take over the CLTC, its functions, and its employees. What is required is a person free of conflicts of interest, untainted by dealing with the CLTC, unconnected with the administration and political process, who is legally savvy and possessed of a track record of trustworthiness. Where can such a person be found? Section 6 of the bill provides the answer. One of our own who is a retired judge. The retired judge would hold the title of temporary receiver, TR. In order for the TR to perform his function, the operations of the CLTC would need to be, quote, frozen. Frozen in order to interdict any further nonfeasance, misfeasance, malfeasance, or cover-up in the granting of leases and licenses. A temporary moratorium is obligatory. Section 1 of the bill enacts a Section 21 GCA, Section 75.107.1a, which establishes that moratorium for a period in excess of 90 days so that the TR can do what is necessary to restore trust in the CLTC. During the moratorium, the TR would have all the responsibility and authority of the CLTC and the Director of Land Management to clean up the CLTC, plus she would be able to petition the Superior Court to void any improperly issued license or lease. In order for the TR to do her or his job, a loophole must be closed. That loophole is the famous 60-day rule, which reads in pertinent part, "In no event may an employee in the classified service be given notice and statement of the charges required by this section after the 60th day, after management knew or should have known the facts or events which form the alleged basis for such action. Any action brought by management in violation of this section is barred, and any decision based on such action is void." The key words are management knew or should have known. Bora's knowledge of nonfeasance, misfeasance, and malfeasance arguably began even before April 19. What's more, news reports show Bora's culpability. Obviously, Bora cannot be trusted to take necessary disciplinary actions. I think, Mr. Chairman, I think time has borne that out. I don't think he's taken any disciplinary action at all. The fix is Bill 5304, which starts the quote, new or should have known period upon the accession of the TR. Absent this salutary provision, those responsible for the CLTC scandal will go scot-free. May 14 was 60 days ago, 60 days before July 13, and time marches on. The TR must promulgate rules and rules that should have been promulgated in 1975 per Public Law 12-226. The rules were never promulgated. Repeating for emphasis, the rules were never promulgated. The following was enacted by Public Law 12-226. 21 GCA 7105, 75103A, the Commission shall adopt rules, regulations, and policies in accordance with Article 3, Chapter 9 of Title 5 of the Guam Code, annotated. That's the administrative adjudication law, Mr. Chairman. Rules proposed by an agency and properly submitted to the legislature are promulgated in only two ways, but confusion arises from some rather unfortunate language in the administrative adjudication law. That is, no rule shall be effective until after compliance with the provisions of this section, and in 90 days shall have elapsed from the date of filing with the Speaker. After the public hearing and the 90-day calendar date from the filing, the Speaker may certify and the Legislative Secretary attest to the default approval of compliant rules and regulations. Next sentence. The legislature may, by passage of a bill into law, approve, disapprove, or amend any rule within 90 calendar days from the date of filing, except that any pending rule shall be deemed disapproved upon adjournment sine die of the legislature. Any amendment to the submitted rule converts the proposed rule into a statute. Like any other statute, such a provision can't be amended by rule, but only by another statute. As a statute, it won't appear in the Guam Administrative Rules and Regulations, which is kept up by the compiler of laws. The expiration of 90 days or a law enacted to approve rules are the only ways rules are promulgated. A statute to disapprove rules effectively deep sixes the rules. The 23rd Guam legislature failed to promulgate rules as required by 12-226, creating confusion by enacting uncodified Public Law 23-38, which contains a statutory provision identified by the misnomer, quote, the Paul Bordallo Rules and Regulations for the Chamorro Land Trust Commission. Because the PBR&R was not promulgated rules, properly promulgated rules, the compiler's website tab for the CLTC looks like this: Chamorro Land Trust, no rules filed. Of course, the site reads no rules filed because no rules were filed. Because of the way Public Law 23-38 is formatted, or actually not formatted, the PBR&R are a return to oral tradition. Non-codification of PL 23-38 and non-promulgation of the PBR&R means that the PBR&R are not on the legal radar. Knowledge of the PBR&R can only be traced by word of mouth back to September 1995. The legislature really screwed this up, Mr. Chairman, and the Chamorro Land Trust Commission had the opportunity to promulgate the rules they should have promulgated. The remedy here is Section 1's Section 75107.1, requiring the TR to promulgate the rules which must contain express provisions dealing with standards of conflict, as you were, standards of conduct, conflicts of interest, disclosure, self-dealing, honesty, ethics, and whistleblower protection. The rules plus the responsibility and authority vested in the TR will allow him to clean up the mess. Thus, the TR's tenure expires 90 days after the promulgation of the rules. At that time, the moratorium expires and a revitalized CLTC can commence the issuance of leases and licenses. Trust, once lost, is difficult to recover. While the creation of the TR would seem to be, quote, strong medicine, nothing short of bringing in one from outside the CLTC and the government will be able to cure the serious malady that is the CLTC today. As is often my custom, I go back to my old Aunt Florence, may she rest in peace, for philosophical guidance. Were she here with us today, Aunt Florence would be heard to say, "A new broom sweeps the cleanest." But I suspect now that with Senator Atta's Bill 326, she's probably spinning in her grave knowing that Senator Atta wants to take that broom and sweep this whole scandal under the rug. I respectfully request that you forthwith pass these salutary remedial bills while incorporating the provisions of Bill 304 therein. And I want to just read footnote 1, if I might. This is footnote 1. I have no pecuniary interest in the subject matter of these bills. Neither I nor any of the people I'm close to have CLTCs nor CLTC leases, nor are any applicants for leases, nor is there any intent to apply in the future. Constitutional issues may plague the CLTC in the future, but today form no part of my motivation for providing this testimony. As a resident, citizen, and taxpayer, my interest in the bills before today bottoms on the beliefs that government agencies' officials must operate in compliance with their organic legislation. When it becomes common knowledge that the CLTC and those charged with administering it, especially DLM Director Michael Bora, fail in this regard, remedial legislature, among other things, is in order. Thank you, Mr. Chairman.
Thank you very much, Senator Klitsky, for your testimony this evening on Bills 283, 284, and we also recognize your suggestion that provisions contained in Bill 304 also be incorporated in any amended version. So appreciate your testimony and your interest in ensuring that the Chamorro Land Trust program restores integrity, or integrity is restored into that particular program by virtue of some of the suggestions proposed in the measures. Any final comments you would like to provide?
Well, just a humble suggestion, Mr. Chairman. Tom Atta seemed to be in something of a rush to get his Bill 326 on the floor, maybe because it's an election year. And it might be possible, if that bill comes to the floor, to, on the floor, amend it by inserting the provisions of these two bills, since they have now had a public hearing. And it would not be necessary for the Speaker to issue a certificate in that regard. That's all I have, Mr. Chairman. Thank you.
Thank you very much for the suggestion. Just one quick question, Senator Klitsky, because understanding the insertion, the possible insertion of these provisions into the other piece of legislation that is going through a super fast track process, that would ratify, it proposes to ratify the decision of the Chamorro Land Trust Commission members. Now, by virtue of inserting some of these provisions, those decisions would have already been made by virtue of the passage of that legislation into law. And then how would this address the concerns that you had just shared with us also.
Okay, well, there are two different classes of leases as I understand it. There's the 102 void leases that 136 would, I guess at Halloween time, it's proper to think in terms of bringing them back from the dead because when they're void, they're dead. You know, it's not a matter of mouth-to-mouth resuscitation or something. They're dead. So it's an interesting question whether the legislature can unvoid something. With respect to the almost 3,000 leases that were voidable, according to the Attorney General, the Land Trust Commission has taken it upon itself to, in one blanket motion, validate all those leases, which I think is rather strange because I watched the hearing on 326 the other night, and one of the people testifying said, you know, the CLTC ought to look at who's using these leases because a lot of people are living on this land that are not the leaseholders. So, you know, to blanket ratify all those leases, I think, is a terrible miscarriage of justice. Now, whether there is a way to undo that action, because what should have happened, each one of those should have been dealt with on a case-by-case basis. Whether it's possible to roll back the CLTC's decision, I have to put that in my too hard file for now, but I could give you a definite maybe. But as far as the other 102, there's no reason to go forward with that. It's a classic boondoggle. What it does is reward people for their misconduct. The other thing is that that's all we've seen. There may be a lot more out there, and there's always the possibility of people living on leaseholds that are not the leaseholders, commercial lessees who are people using commercial property that are not the lessees. There may be a lot of, we may have only seen the tip of a very large iceberg. And the fact that the CLTC has so cavalierly said we've investigated and nobody did anything wrong should give anybody pause. And even if the voidable leases can't be undone, it would be my respectful suggestion to pass the provisions of this bill to find out what's really going on. And then there's the A word, Mr. Chairman, and that is that somebody has got to be held accountable for this. I haven't heard it. I've heard, well, I took it up to CLTC and they gave me the papers, and I haven't heard a single name. I want to know who this they is and who committed the misconduct that allowed all of these things to happen. If we don't do that, we're just setting ourselves up for continuing to do it.
Thank you very much, Senator Klitzky. I appreciate your testimony this evening, and this concludes the public hearing on bills number 284-34 COR and 283-34 COR. The committee will continue to receive testimony on these measures until the close of business Friday, and then the committee report would be finalized for consideration by the main body. Thank you again to all those who provided testimony, and thank you for your support of the initiative. Thank you. Have a good day.